defined a certain number of organizations as hostile.
Judge Halevi, pardon me, sir, the matter of the Lidice children, where does that belong to?
I beg your pardon, count number 12, with which I would wish to deal before I come to the end. And this, according to the order, maybe it would be preferable that I take up count 12 before the last count. There was a discussion which took place about the 100 children from the Czech village of Lidice, which was erased off the earth by the Nazis, and this in revenge for the assassination of Heydrich, all men were killed on the spot, others were sent to camps, and the children were removed from the village. The court will find in the book we submitted to court, and although the book was not submitted for this purpose and was not admitted for this purpose, but there is in the book to reflect reality, court will find picture published after the war. Where are the children of Lidice? We are looking for them. Where are our children? What actually happened to the Lidice children? They were taken to Lodz. And Krumai turned to Eichmann, Krumai, who was stationed there, dealing with the uprooting and deportation of population. Umwanderungszentrale was the name of his office, requesting directives. He believed that the children were intended for Sonderbehandlung, special treatment. And what made him think so? This is well explained by the letter, and a copy of which was submitted by Krumai himself to a German judge when questioned in Germany as a witness for the defense, because he received a letter from Obersturmbannführer Fischer to the effect that the children, amongst them children of 2 and 3 years of age, came without any clothing, only what they had on their little bodies, and were sent through Polish camps towards the east. It was added in the letter, there was a discussion with the counsel for the defense on this point, stressed and underlined that no special care is necessary. Even without this sentence so objected to by the defense on this letter, the very fact that children of the age of 2 and 3 are sent without any clothing, without nothing with them, and the order is given to have them transferred through Polish camps towards the east, and this is authentical. If we even forget this additional sentence on the letter, does it not say what fate was to be expected for those children? It has been argued here that special treatment had more than one meaning. The counsel for the defense submitted documents which prove or pretend to prove that these words did not always mean death. For the sake of argument, let us agree for a moment that this is so. But when Krumai receives these children with such an instruction, he turns to Eichmann because such a kind of Sonderbehandlung, of special treatment, according to what Krumai understands, is a matter for Office 4B4. To camps in the East, children to be taken without any clothing, without any luggage, without anything with them. Sonderbehandlung. The first thing, or one of the institutions he can refer to, is Eichmann, and ask him, what do you say? The document was received from Krumai, including the additional line, which reads, no special care is necessary. And then it becomes quite clear why Krumai is searching the answer for those children who came to him without any previous notice from Eichmann. Such matters are his business. But more than that, if Eichmann is right that he informed Krumai immediately, I do not deal with those children, this has nothing to do with my office, why then did Krumai refer to him once again in connection with 12 additional children from Lidice? Once again he requests directives from Eichmann, and he receives the directives signed by Ginter. Sonderbehandlung with children of 2 or 3 years of age to be taken towards the east without any belongings. This is Eichmann's doings. Krumai turns to him. He is the man to give instructions. And it can be gathered what happened to those children if they were brought in such a state, and if in this state they were sent and were intended for special treatment. The answer is that in Pushkau during the war, some tens of children were seen, and the rumors had it they were Lidice children. There is no contradiction, correct. Here too, they tried to re-Germanize a number of children, and Hanfova testified, and we submitted this to court. Some of the children were taken to Pushkau. And in the Czech book, which we submitted as rebutting evidence, it is said that those children the Germans spared and sentenced to life, hoping to have them annexed and this over the dead bodies of their ancestors to the German nation. Some of them were still in Pushkau. There is no contradiction. But there were not tens, there were only single few, as Hanfova testifies and as the whole book bears evidence. And now to the last count in the indictment.
Our legislator defines as an offense membership in an organization declared as a hostile organization in the judgment of the International Military Tribunal at Nuremberg. This is in paragraph 3 of the law. I shall not discharge my duty properly if I do not tell the court immediately that paragraph 12 of the law as well is to apply here, that is to say, the statute of limitations, and I can ask for authorization with regard to this membership only for a period not exceeding 20 years. This is what it says in paragraph 12 of the law. Only offenses under paragraph 1 and 2 do not become obsolete. Others become obsolete after 20 years. It is an accepted doctrine that once the arrest warrant is issued, the statute of limitations does not apply. And since the arrest warrant against Adolf Eichmann was issued here in May 1960, therefore I can ask for a conviction about his membership of this organization only beginning in May 1940 and onward. Now the membership itself. The International Military Tribunal, this is in the first volume of the Blue Series in English, analyzes the nature of these organizations and states that they are hostile organizations because they all ganged up and conspired to commit criminal offenses. And therefore, any person who occupied executive positions in these organizations will be accused of membership in a hostile organization. The court will recall that the International Military Tribunal wanted only to determine the nature of the framework of these organizations, and then other tribunals and courts had to try and convict members of these groups. And this is how it happened, to the extent that there were such cases. And this is the process of denazification in accordance with this paragraph. On page 264 of the first volume, the International Military Tribunal says about the Gestapo and the SD, after analyzing the emergence and creation of the RSHA.
Was a voluntary organization. It is true that many civil servants and administrative officials were transferred into the security police. The claim that this transfer was compulsory amounts to nothing more than the claim that they had to accept the transfer or resign their positions, with a possibility of having incurred official disfavor. During the war, a member of the security police and SD did not have a free choice of assignments within that organization, and the refusal to accept a particular position, especially when serving in occupied territory, might have led to serious punishment. The fact remains, however, that all members of the security police and SD joined the organization voluntarily under no other sanction than the desire to retain their positions as officials. ולכן המסקנה הסופית
Interpreter's comment, the first words of the quote were the security police and the SD. And therefore, the final conclusion of this, on pages 267 and 268, is that all persons who acted in executive positions in the Gestapo and in the other departments of the RSHA are proclaimed as members of a hostile organization. And there is no longer any distinction whether they did so voluntarily or under compulsion, whether they entered or remained there under compulsion or voluntarily. And I stress this because with regard to the SS, for instance, the judgment expresses this distinction and emphasizes it. And after analyzing the facts about the structure of the SS, which was also proclaimed as a hostile organization, they say on page 273,
the tribunal declares to be criminal, within the meaning of the Charter, the group composed of those persons who had been officially accepted as members of the SS, as enumerated in the preceding paragraph, who became or remained members of the organization with the knowledge that it was being used for the commission of acts declared criminal by Article 6 of the Charter, or who were personally implicated as members of the organization in the commission of such crimes, excluding, however, those who were drafted into membership by the state in such a way as to give them no choice in the matter and who had committed no such crimes.
To put it differently, the judgment makes a distinction and says about the SS only that person who entered it voluntarily and did not and committed crimes or participated in the commission of crimes, he will be charged with membership of a hostile organization. But those people who were mobilized without having a choice and did not commit crimes will not be charged with membership in such an organization. But this is not so with regard to the Gestapo. There they draw no distinction in their conclusions between voluntary entry and remaining, but the court ruled that whether the people did so voluntarily or involuntarily, membership in such an organization was a crime and every member will bear responsibility. With regard to Adolf Eichmann, we say and we know that he entered the SS voluntarily, that he entered the SD much before the outbreak of war. He says there was some kind of mistake, he wanted something else, and eventually he found himself in the SD. But all of this was much, much before the outbreak of the war, and at that time he certainly had free choice, except for this oath about which he speaks, because he had taken an oath of allegiance to the SD, and he admitted in the examination that he entered voluntarily and stayed on willingly in these organizations as long as they were in existence. According to our law, voluntary or involuntary membership makes no difference. The very fact of membership is defined in paragraph 3 as an offense. But this is a theoretical distinction with regard to Eichmann, because he admitted that he joined voluntarily and stayed on voluntarily. And in this framework of the SS, as I said yesterday, there applies to him paragraph 47 of the law of jurisdiction, and the court will find in Exhibit T 140T and 140TA the publications of the official instructions for SS and police people, and this includes this paragraph. And the court will find in Exhibit T 646 that beginning on the 17th of October 1939, the German law of military jurisdiction was applied to all of the SS. And the SS people could not use the defense, even in the German courts, that they were merely doing that under duress and under compulsion, that this is how they had committed all of their crimes. Needless to recall once more that this defense was of no use to them at the International Military Tribunal and the other Nuremberg military tribunals. But maybe I should only recall the judgment of the German Court of Appeals, a judgment which we find in the second volume of the Entscheidungen des Bundesgerichtshofes, decisions of the Federal Court, pages 252 through 258. I have a long series of decisions of German courts in this matter, but I think I shall content myself with referring to one of them. If the court is interested in seeing others, they are at the disposal of your honors.
President of Court, the book mentioned by you, you may submit to court, as well as the right collection. You will have to submit the volumes to which reference was made by you. I do not think it is in the library of the High Court.
So maybe our set is borrowed from there. And one more remark. With regard to the magazine Life and the articles which we showed to the accused during his interrogation, and this was shown to him in his interrogation at Bureau 06, I would request the court to note that first the accused made his comments about this article, and later, when his comments grew in number, as he testified, as Superintendent Less testified here, he undertook to mark with agreed notations those passages about which he had reservations, and therefore
wish to touch upon now the matter of conspiracy. What do you request in conclusion, in summing up?
My request, Your Honor, is that it be ruled that Eichmann was involved in a conspiracy to commit crimes against notations, those passages about which he had reservations, and therefore
wish to touch upon now the matter of conspiracy. What do you request in conclusion, in summing up?
My request, Your Honor, is that it be ruled that Eichmann was involved in a conspiracy to commit crimes against the Jewish people and against humanity in all their stages. That he occupied a central position in this conspiracy in its executive stage. And that therefore he is responsible for all the consequences, all the acts committed by himself and by others because of that conspiracy.
President of Court, this is paragraph 24 in our law. Do you plead this alternatively to blame him, to accuse him of conspiracy?
No, the charge of conspiracy as such exists if nothing was carried out on account of this conspiracy. This in itself is a crime, but once acts were committed because of that conspiracy and following that conspiracy, then each and every one of the conspirators, on the basis of the Kaiser principle, is responsible for the acts committed in the course of this conspiracy. And this is distinct from paragraph 24.
President of Court, but this when there is a conviction on the charge of conspiracy.
No, not necessarily, and it is stated explicitly in that judgment. The court can find this in the Kaiser judgment, that quite distinctly from any charge of conspiracy, and that there is even no need to charge a man with conspiracy. And in the Kaiser case, it was not even included in the indictment.
President of Court, but he was convicted of conspiracy.
No, he was convicted as an accessory to the crime. These people were not convicted of the conspiracy, but as having committed the crimes which emanated therefrom.
Judge Halevi, I am not so sure that this is the correct interpretation of the Kaiser precedent. This may transpire of a single diction of the judges, but on the face of it, it seems that all these rulings were made only in connection with the conviction of conspiracy, according to the Criminal Code Ordinance, whilst the matter of accessories to a crime, paragraphs 23 and 24, these principles do not apply. And here we deal with section 23 only.
Yes, 23. Your Honor, with all due respect, I would like to refer to the references used in the Kaiser judgment in United States versus Boyd. And they said that the principle, the elementary principle, is the well-known doctrine that any person, perforce he intends the consequences of his action, and whenever he enters into a pact with another person to perform an illegal act, he thereby agrees implicitly that his acts be employed by the other conspirators for the purpose of attaining that objective, and each and every one of them will be charged and liable for all that was committed, everything committed by the other conspirators as a consequence of the conspiracy. That is to say, not only the conspiracy, because this is not the innovation here in Kaiser. This is not the innovation in the Sweetland case either. Conspiracy as such was known a long time in advance. And in what did the late Justice Goitein see the progress, the innovation in the Sweetland case? That it was ruled here as a matter of substantive principle in common law, not only as a principle of the law of evidence, that the conspirators are responsible one for the acts of the other, on the strength of the independent significance of the conspiracy, and this is distinct from the law of criminal evidence. And even if we did not have all the paragraphs about accomplices and all the assumptions deriving therefrom, then on the strength of the criminal conspiracy law itself, this is the doctrine here, we would then have to rule that this principle charges each and every one of the conspirators with criminal responsibility for actions committed within the framework of the conspiracy and for its promotion. This is stated explicitly. For instance, on page 5. The quotation is in the middle of the page. It is my view that one does not even have to employ paragraphs 23, 24, and 25, which do not deal directly with the crime of conspiracy, but mainly the question of complicity in crime. Paragraphs 35 and 36 stand independently and describe a specific offense. According to paragraph 4 of this ordinance, we have to interpret this according to English law. I hold, in accordance with English law, that the crime of conspiracy embraces a substantive law of mutual responsibility among the conspirators, and that without any connection with the general doctrines of complicity in crime. May I say that the word is not here conspiracy, but a relationship. The Hebrew word kesher may be misleading here. There is no relationship here to the general doctrine. They are not mutually responsible because they are accomplices in a crime in the sense of chapter 5 of the Criminal Code Ordinance, but because of an independent rule relating to the law on conspiracy.
That is, that there should be a conviction on the charge of conspiracy.
Yes, it says towards the end that the judge was right in convicting each one of the appellants on counts in the indictment, even though the active complicity of each one of them in the commission of a specific offense had not been proved each time.
Judge Halevi, in the indictment it says that 14 counts are included, 3 counts charged against some of the appellants, and they are charged with conspiracy.
No, Your Honor. There they had precisely this very question, that the matter of the conspiracy was not mentioned in the indictment.
Judge Halevi, but 3 charges are included of special conspiracy.
Yes, specific conspiracy. And the court says repeatedly in other passages too that there is no need at all to refer to this in the indictment. And the legislator, rather the court adds on page 4, our page 4, the question arises whether this rule is really confined to the law of evidence only, or whether we have a substantive rule here which teaches that one conspirator is responsible for the acts of another conspirator on condition that the act was performed as part of the conspiracy and for its advancement. There is no doubt that the learned judge below could have used the evidence of action on one conspirator as admissible evidence against all the conspirators from a substantive point of view. That is to say, the other conspirators may be convicted for the same act even though they did not participate in its commission. That is the main thing. This is what I wish to stress. In other words, a conspirator is to be regarded as an agent of the other conspirators, and his acts are to be regarded as acts of a party to the crime in the sense of paragraph 24 of the Criminal Code Ordinance. But one does not have to use paragraph 24 because he becomes a partner to the crime as though paragraph 24 had been specifically applied.
President of Court. Judge Rave, I have one more legal question, Mr. Hausner. This in connection with the corroboration in regard to a party to a crime. You told the court that in this matter, in each case, there is corroboration by documents. Now, it is quite possible that such documents also come from the hands of a party to the crime. For instance, if I remember the case of the skeletons, we have the testimony by Sievers.
Yes, Sievers.
And a number of letters addressed to Eichmann, not letters written by Eichmann. I do not mean to say that in this matter there is no other corroboration. But as an example, let us say that there was nothing else to corroborate. Or again, the question of the gas. The poison gas.